From Ukraine to Gaza to Sudan, it's difficult not to feel like we are witnessing the breakdown of international law and the rules-based international order. All of this while the triple planetary crisis of climate change, biodiversity devastation and pollution rages on. And we indulge ourselves in debates about symptoms rather than root causes, pointing the finger over there, wherever over there is. We're also beginning to see the full frontal attack on human rights discourse. It's as if equality has become a dirty word, when the reality is that our well-being and our strength of our economies and our societies depend on cohesive, tolerant societies underpinned by human rights, democracy, the rule of law, and ambitious public policy. Despite all of this, though, there are slivers of hope, as Siobhan has mentioned. Slivers of hope in the actions of individuals, lawyers, medics, human rights defenders, and others. And this is especially the case in conflict zones. The determination of the people of Ukraine, for instance, is the literal embodiment of European values. The Council of Europe member states have responded decisively by expelling Russia, first time in the history of the organisation, and setting up the enlarged partial agreement for the register of damage caused by the aggression. Small countries like Ireland are having an impact internationally, be it at diplomatic level, special procedures mandate holders, as well as many humanitarian and civil society organisations. And we must not forget that we have elaborate international law standards, such as the European Convention on Human Rights, the Council of Europe Convention for Prevention of Torture, and the European Social Charter, and a comprehensive machinery to support their implementation. So we can't allow ourselves to lapse into hopelessness. We are at a defining moment for human rights and the international order. And despite its profound flaws, we can't allow international human rights systems to be eroded further. We must strengthen the systems we have to scrutinise, develop and defend international law in line with the object and purpose that it was designed to deliver. To bolster our international mandate holders, including UN special procedures, and the likes of the Council of Europe Commissioner for Human Rights. To empower human rights defenders in meaningful ways, and of course to support those most directly affected by conflict, including through the pursuit of accountability. This, ladies and gentlemen, is the spirit of my book. It is concerned with the impact of situations of unresolved conflict and contestation on the effectiveness of Europe's human rights framework system within the framework of the Council of Europe. It's about people and their rights. It's about leaving no one behind. It's an expression of normative pragmatism, not blind idealism. It acknowledges that conflict is the new reality in Europe, and it confronts this head-on. It argues for a more nuanced, committed, sophisticated level of engagement, thinking about security and economies, of course, but also and no less humanity and human rights. My central contention is that member states of the Council of Europe share a collective public order imperative to ensure that the Council of Europe human rights system is as effective as possible in contested and conflict-affected territories. As Mary Robinson said at the conference in Galway a number of years ago, it's a frequently observed paradox of international human rights law that it often lacks effectiveness in the areas where it's needed most. In situations of national emergency, in times of war, when principles of basic international humanitarian law are invariably cast aside with impunity, and in areas of conflicts that defy the probing light of accountability. The Council of Europe cannot resolve conflict, but more can and must be done for the rights holders it was designed to protect. Europe has changed profoundly since I first proposed this research. It was then a seemingly obscure topic, not even at the fringes of human rights legal debates. It simply didn't feature at all. I was advised at the time not to examine the topic because it was an impossible problem. Since then, sadly, the topic has become more and more relevant. So what do I mean by grey zones? There are many regions in Europe affected by some form of conflict or political contestation. These conflicts range from the trivial, such as who has jurisdiction over the summit of Mont Blanc, to the caustic, as we see in Russia's aggression in Ukraine. Very few are actually currently active conflicts, armed conflicts. As such, this book is neither about jus ad bellum, that is to say, the conditions under which states resort to war, or the use of armed force in general, nor is it focused on jus in bello, the body of law seeking to regulate the conduct of parties engaged in an armed conflict. Instead, it's about the application and effectiveness of international human rights law, European human rights law in particular, and the system that is established under public international law to structure, advance and interpret those standards. It is principally concerned with regions not currently experiencing active armed conflict, though of course it is directly relevant to all areas of conflict in Europe. Examples include in Eastern Europe, Transnistria in Moldova, in the South Caucasus, Abkhazia and South Ossetia in Georgia, both constitutive parts of Georgia, but effectively occupied by Russia. In the Eastern Mediterranean, there is Northern Cyprus, occupied by Turkey since the 1970s. There was a region called Nagorno-Karabakh in Azerbaijan, though as of the 1st of January this year, all of the state institutions have been dissolved and almost the entire population of 100,000 people, predominantly Armenians, were forced to flee in the weekend. And although fundamentally different from all the others, in the Western Balkans there's Kosovo, a country of 2 million people unable still to access the European Court of Human Rights. Overall, more than 10 million people live in these regions. And what is common to all of them is that international human rights mechanisms are unable to function freely and effectively, depriving the people of access to the full rigours of Europe's human rights system. This not only presents a normative problem of rights and equality, it represents a fundamental threat, I argue, to the integrity of Europe's human rights system. Yet, these conflicts have largely been ignored for decades. They've been accepted not as temporary anomalies, but as semi-permanent grey zones, where there's a lack of clarity over who exercises jurisdiction and what human rights obligations and duties apply. I accept that the term grey zones is not particularly elegant. I don't actually like it, as it conjures up images of greyed out parts of a map, adding to a sense of exclusion and isolation for people living in these regions. But it gives a very strong sense of legal uncertainty. The Parliamentary Assembly of the Council of Europe in its resolution 2240 defined grey zones as regions within the mandates of those bodies which are not in the control, which are under the control of de facto authorities. The diversity of conflicts and what constitutes de facto authorities is extensive, and one must be very careful not to conflate them, or we risk drawing false equivalences. For instance, Russia's occupation of Transnistria bears no historical or other resemblance to Kosovo's path to independence. What is similar, though, is what I describe in the book as outcome characteristics. That is the lack of full and unrestricted access to the monitoring and advisory mechanisms, as opposed to intrinsic characteristics like culture, history, politics, social structure, and so on. Accountability gaps create the space for human rights violations. These include the likes of torture and ill-treatment, enforced disappearances, sexual and gender-based violence, displacement, discrimination, not to mention impunity and the lack of access to justice. Over time, these grey zones have become the normalised exception in the Council of Europe, with their existence largely accepted as a matter of fact, rather than being a problem of first principles. The Council of Europe, in particular the Committee of Ministers and the Secretary-General, simply have not given this problem the political and institutional focus it deserves. The Council of Europe was established in the wake of war. It was established to prevent war by fostering unity and cooperation amongst its members, a task it is uniquely ill-equipped to fulfill. The CUE obviously cannot prevent war. In fact, it has admitted members at war, in the case of Russia, when Chechnya was raging. Armed conflict, if you want to be technical, but there we go. What it can do, though, and what it has been extraordinarily successful at, is promoting cooperation and serving as a human rights watchdog, holding the mirror up to member states' governments, reminding them of their obligations and speaking out when progress is unsatisfactory. It comprises three fundamental and interdependent components: a committee of ministers, a parliamentary assembly, and a secretariat. And it operates on the basis of developing law and standards, monitoring implementation and practice, and supporting progress. There is also the European Court of Human Rights, the enforcement mechanism for the ECHR. Council of Europe treaties are adopted and applicable throughout the whole territory of each contracting party, and all member states are bound to guarantee, not only in theory but also in practice, the rights and freedoms protected by the European Convention on Human Rights to all individuals within their jurisdiction, in accordance with Article 1 of the Convention. In other words, the ECHR normally applies in the whole territory of state parties, even in areas that states do not effectively control. This presumption of jurisdiction is important, as it gives rise to an obligation to pursue meaningful progress on human rights issues, for example, by allowing access to monitoring and advisory mechanisms to these regions. That's nice, but the challenge really is reconciling this universalist spirit with the realpolitik and with the reality on the ground. In practice, if a territorial state says it cannot guarantee rights in the grey zone, the CUE has tended to leave it at that, especially if it's suggested that the CUE might inadvertently legitimise de facto actors by engaging with them. This book strongly contests this premise. Territorial conflict has been treated as a sovereign or bilateral issue for too long, despite the protection of human rights being a legitimate statutory interest of the organisation. Working to improve human rights protection should never be conflated with recognition. It is status neutral in its very essence, and the leadership of the Council of Europe should be more clear on this. This book argues that whilst human rights duties are the primary responsibility of states, the CUE member states have a collective responsibility towards the statute as a matter of European public order. With the Committee of Ministers in the pace for many years, tiptoeing around the edges of conflict, the European Court of Human Rights has become ground zero for lawfare. It has focused its energy on the question of jurisdiction under Article 1, and to a lesser extent, the issue of attribution. In Cyprus and Turkey, the court noted that any territorial restriction on the realisation of rights would not only seriously weaken the role of the court, but it would also diminish the overall effectiveness of the Convention as a constitutional instrument of European public order. However, from that point on, the court has been consistently inconsistent. It has oscillated between highly liberal approaches, such as in cases linked to Northern Cyprus, in which the court effectively sees Northern Cyprus as an extension of Turkey, to the unjustifiably restrictive approaches in the case of Bankovic, which considered that the NATO bombing of Belgrade did not give rise to any exercise of power or control over the people being bombed from the sky, and therefore no jurisdictional link could be made under the European Convention on Human Rights to the states in question, and partly back again. Judge Bonello famously observed in a separate opinion in the case of Al-Skani that the court has been bedeviled by an inability or unwillingness to establish a coherent, axiomatic regime grounded in essential basics and even-handedly applicable across the widest spectrum of jurisdictional controversies. My friend Stuart Wallace put it even more succinctly when he said, Article 1 case law is a deeply complex, meandering hodgepodge. Then in 2021 we arrive at Georgia v. Russia 2, in which the court cited the general inability to speak of effective control over an area during an international armed conflict, which precluded the possibility of establishing jurisdiction at that particular point in time. The court went further to articulate the more general view that the very reality of armed confrontation and fighting between any military force seeking to establish control over an area in a context of chaos means that there is no control over an area. The judgment seems to say that for those specific periods, 5 minutes, 5 days, 5 weeks, 5 years, no control, no jurisdiction, no accountability under the European Convention on Human Rights. This is very likely to be undone in due course, but it has cast a particularly dark shadow on the court's case law, especially when considered in the context of Russia's imperial war of aggression on Ukraine. Furthermore, the court and the Committee of Ministers also face enormous implementation challenges in cases related to grey zones. Judgments are verging on being inexecutable, which highlights the limits of the court in affecting general or individual justice in practice. In many ways, the court is being asked questions it is ill-equipped to answer. The book, therefore, argues, probably controversially, that we must look beyond the court to protect the court. We must look to the broader COE apparatus. With that in mind, the book proposes reconceptualizing the Council of Europe's system from one traditionally seen as a hierarchy of autonomous institutions, biased often towards the court, to an understanding of a matrix of mutually reinforcing judicial and non-judicial components, for which member states have collective responsibility. That system includes various statutory and monitoring bodies, which work on ill treatment in places of detention, CPT, human trafficking, GRETA, racism, EPRI, gender-based violence, GREVIO, corruption, GRECO, and the protection of the rule of law and constitutional standards through the Venice Commission. The Council of Europe Commissioner for Human Rights is also uniquely placed to play a proactive role in relation to areas of conflict. The Secretary General, though, is the operational guardian of the statute. And her role is not only to operationalise political priorities of the member states, but also to shape and delimit those priorities in line with her obligations under the statute. This brings us back to the question I asked at the very outset. Do we see the Council of Europe as a functional instrument, or an accessory of state will, or as having a more fundamental kind of normative agency to advance the principles of universality? It is clear to me, at least, that the Secretary General has emerged in the manoeuvre, though I accept fully that striking an appropriate balance between being operationally servile and normatively assertive with member states is an exceptionally delicate one. We often refer to the political will of governments. This book argues we should pay more attention to the normative will of the Secretary General based on the object and purpose of the Council of Europe statute. Having said all that, I don't want to give the impression that the Council of Europe has done nothing in relation to conflict. True, much of its action has been declaratory in nature, but it has been enormously innovative at times. The Council of Europe has played a key role, often behind the scenes, during the conflicts in former Yugoslavia, for example. It has played a key role in the institutional development in post-war Bosnia and Herzegovina and Kosovo and other regions. Monitoring bodies have visited some of these grey zones on some occasions, but typically practice has been patchy and inconsistent. The Committee for the Prevention of Torture, for example, succeeded in visiting Transnistria on numerous occasions with the consent of the Moldovan government up until 2010, when a visit was interrupted, access restricted by the de facto authorities, and there's been no public information on what has happened ever since, 13 years later. Similarly, the Commissioner for Human Rights has visited Kosovo, Abkhazia, the Karabakh region, Northern Cyprus, Transnistria, but again, these visits have often been quite ad hoc and sensitive. For the purposes of this book, the experience of engagement with Kosovo offers particular food for thought. It has, and I don't mean this to sound offensive to Kosovo, it's been a laboratory of human rights practice. Kosovo has deeply embedded the European Convention of Human Rights into its domestic legal order since 1999 and retained an open pro-European stance, often voluntarily subscribing to Council of Europe standards, which it did not have to do, such as the Istanbul Convention, and consenting to ad hoc arrangements for monitoring and monitoring-like programs. A policy of standards over status flowed from the Ahtisaari Plan, which served as an early framework for Council of Europe engagement in Kosovo. Monitoring-like processes have been set up. A bespoke cooperation framework developed. A policy expressed by the Secretary-General of functional capacity was constituted to allow the Council of Europe to engage directly with Kosovo, circumventing the UN mission in Kosovo. Kosovo became a full member of the European Commission for Democracy through Law, the Venice Commission, and the Council of Europe Development Bank. Yet people in Kosovo still do not have access to the European Court of Human Rights for the time being. This book argues that Kosovo is a model for functional engagement, as part of what I call a judicious rapprochement towards grey zones. Rapprochement is another word for a resumption of engagement with the issues affecting rights holders in grey zones. This would be a policy choice to transform ideas of a very high level abstraction into concrete practical measures tailored to each specific context. So what can be done? Member states could, for instance, explicitly acknowledge the risk unresolved conflicts pose to rights holders and the broader Council of Europe system as a means of establishing the necessary basis for further action. The presumption of territorial jurisdiction principle should be emphasised, as well as the status neutrality of the Council of Europe, which will reassure territorial states with their legitimate concerns on the one hand, whilst also supporting the presumption of access principle for monitoring bodies on the other. Monitoring mechanisms should audit their practice vis-à-vis these regions. This could be done through a special representative of the Secretary-General mandate or an appropriate subcommittee of the Committee of Ministers to examine the operational gaps within the Council of Europe and plan how to address them. The Secretary-General should examine the possibility to replicate the principle of engagement on the basis of functional capacity in other regions where it is possible to do so. The little-known Council of Europe Confidence Building Measures programme should become the COE's central avenue for cooperation on human rights issues in grey zones. The Parliamentary Assembly could build on the excellent work it has done in relation to Nagorno-Karabakh, Kosovo and elsewhere through relevant committees dealing with monitoring human rights and the rule of law. Human rights defenders, civil society, journalists and academia should be engaged in much more meaningful ways. The door for cooperation should be always open. There are many, many other possibilities, but the important thing is they need to start with a willingness to do something. This is all the more important now that Russia is no longer a member state of the Council of Europe, nor is it a party to the European Convention on Human Rights. It remains a party to the European Convention for Prevention of Torture. As such, responses to areas Russia occupies will need to be even more concerted, nuanced, and patient. Ladies and gentlemen, this is not an easy topic, with no easy solutions. The basic universalist principles underpinning Europe's human rights system must guide us. Human rights are universal, indivisible and interdependent. No one should be left behind in any discussion about conflict. People must be first. In areas of conflict, that not only requires us not to be complacent, but to be proactive and determined. To make the most of the systems that we have, which are unique and powerful, and can have a significant impact with the right strategic direction and resourcing. If our approach to this issue is not well defined, structured, and predictable, it is certain to be scattered ad hoc and random. To conclude, I ask, if not the Council of Europe, then what? And if not now, then when? Thank you.